Folks, hello and welcome to Tavern Chat. I'm your host, your bartender in the OSR, Eric Tenkar, and this is the Open Game License 1.1 intro. So, why can I show it now? Well, somebody took the PDF or a PDF, maybe it wasn't the exact same version that I had, and ripped out the identifiers and has shared it online. I will include a link to ogl.battlezoo.com so you can snag a copy for yourself, read it for yourself. You should know what's in here. I don't care if you're a publisher or not a publisher, you're just a consumer or you're a creator. Know what has been written, know what the game plan is, or maybe if we're lucky, it was, on how to essentially fuck with you. So, it's 15 pages converted. I don't think we're going to read all 15 pages, but hey, you never know. D&D is all about creativity. Whatever. Historically, we have allowed fans through our open game license to make and sell commercial content using our intellectual property via the system's reference document. This practice has continued for more than 20 years, and we continue to support it today. Uh-huh. Well, let's just see how long that lasts for. A lot has changed over the last half century. I went over this yesterday. Look in that one. This is where the most important part of this is the revised license is intended to protect the D&D brand by reducing creator confusion. I don't know if any creators were confused, but all right. Preventing bad actors from tarnishing it. This is the, I'm going to guess, I've said it before. Well, it's the new TSR Dave Johnson. It is Wenger and Raggy and Zach Smith and the evil people that are tarnishing your SRD and preventing large businesses from profiting off it without proper checks and balances. Checks and balances. Oh, you're making too much money. Yo, give us your shit. That's the checks and balance, right? Come on. So, now here's what people go, well, this isn't written like a license. This is the actual license is available through the hyperlinks below. And if you're comfortable with legalese or somehow enjoy reading legalese, feel free to jump ahead to those links. Okay. So that's why this is written very informally. I call this the layman's version of the license. We've included explanations and examples alongside the legal language to help make the OGL easier to understand and comply with. You can get to those comments by clicking the link at each section. By the way, the links are dead. I'm not clicking on any links. Below are a few facts. What is non-commercial use of SRD? If no money or anything else of value is changing hands to get access to the things you create using SRD content, that's non-commercial use, and it's covered by and subject to the terms of the OGL non-commercial. If any form of payment or income for access to your work is involved, or is specific to a particular work, even if it's just $1, it's OGL commercial. To be clear, crowdfunding a new project is commercial use. Now they'll tell you it isn't. You're not paying for it. You're donating, right? No, Wizards of the Coast is like, yeah, that's bullshit. Membership fees, subscriptions, Patreon patrons, as a condition of accessing your work is commercial. Voluntary donations via tipping mechanisms or sites where you're providing your content for free, regardless of those donation/tips, is not. So they're being very strict. But okay, so what are my options for making D&D related content? If you're going to use SRD content to make tabletop role-playing games and game supplements on a non-commercial basis, the OGL non-commercial applies. If you're going to make content we make available for third-party use to make tabletop role-playing games and game supplements on a commercial basis, and only want to use material from the SRD, not stuff like the Forgotten Realms, then the OGL commercial has you covered. If you want to publish work that uses the Forgotten Realm setting or other content not included in the SRD, that's under the Dungeon Masters Guild. So, and now I'm going to make an observation. If you go into if you use the OGL commercial, Wizards of the Coast gets all rights to your work. You retain ownership, but they can do whatever they want with it, and they don't have to pay you. That's pretty much the same as the Dungeon Masters Guild, but at least they give you a sales platform to sell your shit. They take half your money, but they give you a sales platform. And then we go under the different levels of commercial. If you hit 750,000, you've leveled up. I swear to God, it's in here. So they talk about commercial and how do I agree to the commercial terms. Anyone publishing content under the commercial license will need to register that content with us by creating an account at dndbeyond.com, providing us with identifying information, such as the name of the person or entity creating the work, the title of the new work, a summary of the work, and once the work is available to others, a copy of the work. When you complete that registration, you will also be confirming your agreement to the terms of the OGL commercial. And then they give you the link to the OGL commercial. And if you don't like those terms, and that's fine, it just means you cannot earn income from any SRD-based D&D content you create on or after January 13th, 2023. Now, it needs to either operate under the new OGL non-commercial, strike a custom deal for your project, or, well, there's no other or. You either sign 1.1 or you pound sand. Now, why are we updating? Why is Wizards updating to these new OGL terms? Well, a lot has changed since the old OGL was launched, and that means the old license has some unintended applications we need to fix. For example, when we released OGL 1.0a, YouTube, apps, blockchain, crowdfunding, and other now everyday technologies and distribution channels didn't really exist in the way they do now. OGL wasn't intended to fund major competitors, Paizo, Cobalt Press, even Goodman Games, one of their partners, or partners no more, I don't know. And it wasn't intended to allow people to make D&D apps, videos, or anything other than printed or printable materials for use while gaming. We are updating the OGL to make, in part, to make that very clear. So just to be very clear, they are not simplifying the OGL. They are not making it easier for you to use. They are making it much more restrictive. Well, I guess in a way that's easier to use, right? Now, you can only use it for print and PDF or EPUB. What if I want to put it on a blog? No blog. Gee, what if I want to write my content down in pencil and sell it? Nope. That would be a violation, actually, because it's not static. I can erase pencil. Ooh, they didn't cover that, but I think that's probably there too. Talking about rules lawyering, they've gone all 100% rules lawyer. Additionally, over time, the old OGL incorporated some confusing and even contradictory provisions. And it was also written in fairly dense legal language. So we're going to, we're updating it to take into account developments since it was last revised, which apparently is their belief that there's a court case that allows them to take perpetual and kill it. Like perpetual until we say it's revoked. That is apparently what they are sticking their hat on. And breaking out commercial use into a separate category. And we're also simplifying the language because it was so hard to understand. Everybody had a problem with the OGL, right? No, very few people did. But we're going to make it simplified and streamline the provision. Again, streamlined. Print and electronic static format only. So that it's easier to understand and comply with. For even more clarity, because you are that now forbidden word that we cannot say on YouTube. But how about this? You're mentally deficient because you couldn't understand the original OGL because you made money off it. You were making money off it for over 2 decades. So we're going to clarify why we can't have that happening anymore. You can access the relevant comment links in the licensed documents. Thank God I don't have access to that over here. We strongly believe in the power of creativity and the goal of the old OGL as we now interpret it. Oh, sorry, that's not really there. And this new OGL revision in both commercial and non-commercial form is helping our incredible community to build and share campaigns, supplements, and other content that enriches the way we play D&D with lots of caveats, right? But you don't worry about that. Okay. Who can I contact if I don't understand something or need help? Well, they're going to have people so you can contact. They'll have a phone number, 1-800-GO-FUCK-YOURSELF. I am quite sure you're going to be told, just sign the contract, but I have questions about it. No, that's okay. The contract is fine. Don't worry about it. Just sign your name and your soul down on the contract, and we'll be good. Now, the preceding material is not part of the contract, so you don't have to include that in your book. Okay. OGL 1.1, non-commercial and commercial. We're not going to get stuck on the non-commercial, except for, well, I guess we should. Any non-commercial use of licensed content defined below is subject to this agreement. By using licensed content in this manner, you agree to the terms of this agreement. This agreement contains your consent to jurisdiction in Washington State for any disputes between you and us, and your agreement that any such disputes will be resolved in individual litigation heard by a judge rather than a jury, because God forbid we put a jury out there. They might think that we're assholes for doing this. So we don't want that to happen. We'd rather have a judge. If a dispute ever occurs, we hope you agree with us that it's best all around if it's handled quickly, efficiently, and with the least expense possible. We will bleed you dry, by the way. Just take that into account. Content covered and not. D&D involves several different categories of content created by the creator and by Wizards of the Coast and its parent affiliates, suppliers, and distributors. Here are the different kinds of content. Usable content is included in the SRD 5.1. Now, I know that there are somebody's going to go, well, they don't mention SRD 3.0 or 3.5. No, they don't. But we'll continue. Including basic game mechanics and a curated selection of classes, monsters, spells, and items that allow you to make content compatible with Dungeons & Dragons 5th edition. No, not usable content. This is D&D content has been or later will be produced as official. That is, released by Wizards of the Coast and any of its predecessors or successors and is not present in the SRD. It's not in the SRD, and it's D&D content that is official, verboten. That's not too big. We're okay with that, right? But you need some license if you want to include it. Your content, these are the characters, classes, spells, settings, items, new rules, and other creations that you have crafted. They are your original contributions to the work that you want to sell. The license permits you to combine your content with the licensed content and commercially distribute the resulting works. Works covered. The license only applies to materials you create for use in role-playing games or as game supplement, and only as printed media and static electronic files, such as EPUBs and PDFs. It does not allow distribution of any other form of media and does not apply to creation of anything else. And if you're a blogger and you create material that would fall under the SRD, sit and rotate, because you're not going to get much out of this. To be clear, OGL non-commercial only allows for creation of role-playing games, supplements, and printed media, and static file formats. It does not allow for anything else, including but not limited to things like, remember, non-commercial. You can't do videos, virtual tabletops, or VTT campaigns. VTT campaigns, which means you can't do your real play videos, or whatever they call that shit, the Matt Mercer effect. Nope, you can't do it. You can't use our words in your campaign. when you're going to record it. Computer games, novels, apps, graphic novels, music, songs, dances, pantomimes, because they're really, I guess we got to make sure we have that box around us that Wizard of the Coast is putting. Oh, yeah. And I love the fact that it's comma and then a period, because I think they planned on putting more stuff there and then they decided not to. You may engage in these activities only to the extent allowed under the Wizards of the Coast fan content policy or separate agreement between you and us. Oh my God. Then we go to here's the non-commercial. Must meet all the following. Yeah. We're gonna no, I don't think any of my listeners, my viewers are worried about non-commercial. If you're gonna go non-commercial, you're probably not gonna use the OGL at all. I could be wrong. As we said in the intro, commercial distribution is end distribution. You get paid in any form: money, crypto, barter. I don't know. Your brother doing your chores for a week. Look at that. Whatever. Little favors. Wink, wink. It does not include donations people give you to support your work, as long as they can have access to your work for free if they choose to. And you inform them of that in a clear and obvious way. Ownership. You agree we own copyright, trademark, and patent rights, if any, in the licensed content and the unlicensed content. Okay. Now, the unlicensed content, wouldn't that be your content? And then they own the copyright and trademark rights? I didn't catch that in my first reading of this. That sounds a little fugazi. I am not a lawyer. Maybe that sounds fine to you. We reserve all rights not expressly given to you through this agreement. You agree to include any copyright or other rights notices included with the licensed content in your licensed works. And you may not impose any additional, different, or inconsistent terms or conditions with respect to the licensed content in any license you grant to any licensed works. Now, that is definitely fucking legal use. Identification of licensed work. You must identify in your licensed work which content is licensed content and which content is your content in a way that allows the reader of your licensed work to understand without checking out any other document. And now we go to the comment. You can identify content in any manner you want to. You can use a different font for licensed content, an asterisk, you can underline it, you can highlight it, but it has, you can cite to the SRD whenever you use licensed content. Put a separate index, a list in the back of your licensed work that lists out what exactly you use from the SRD. You can even figure out some other idea that we haven't thought about, but you did. How you do it is up to you. If your readers can't tell what's what, we're satisfied. But if it's not enough to simply include a statement that your licensed work includes licensed content. What used to be called open game content. Again, why are we calling this license the open game license when there's no open game content in it? There's licensed content in it. Licensed game license. Oh, gee. LGL. Licensed game license. That's what they're telling you this is. No. Because they have to go with the illusion, go with the fallacy that it's an open license. Just come on. I know it smells like shit and it looks like shit and you stuck your finger in it and you put it towards your mouth and then, yeah, that was shit. But we're telling you it ain't shit. Ew. It ain't shit, Rach. It ain't shit.
All I can say is ew.
All right? It's chocolate ice cream that's just melting in front of you, and you better eat it fast, because if you don't, you'll never get another chance. But once you do, you can't go back. So, share alike. We are letting you use licensed content for free because you are using it on a non-commercial basis. If you want to better protect your ownership, you may want the open game license commercial. Oh my God. You must distribute a copy of the license alongside your work. For clarity, the license should probably appear at the front or the back of your book, but it must be in the book. Now, with the original OGL, it just had to accompany it. So, literally, you could just, distribute a page with your book. The version of the license you use, The version of the license you enclose with your work must be this license. You must keep intact all notices that refer to it, and you must keep its disclaimer of warranties. You warranty that, okay, you are over 18 years of age, or if younger, have your parent or guardian review these terms and agree to them on your behalf. You have power, the authority, and the right to enter into this agreement and perform the obligations it asks of you. If we require additional paperwork or documentation from you in connection with licensed work, you will provide it to us as soon as possible. You will comply with any of the requirements we have related to this agreement, such as registering or creating an account with us. Your licensed works do not and will not infringe upon any third party's intellectual property rights or any of our rights not licensed to you via this agreement or any other. You will not state, suggest, or imply that your licensed works are endorsed by or associated with us, except that you must include the text of this OGL non-commercial. Oh my, enough. Its agreement is, along with the OGL commercial, an update to the previously available OGL 1.0A, which is no longer an authorized license agreement. Why is that text important? Because they're saying, well, the OGL 1.0A says it's usable, and you can use any authorized version of the license, the OGL, with any official version of the game rules, and you're good. And now they're saying it's not authorized. And that sentence is the sentence that tells you what Wizards of the Coast thinks of you as a publisher, a creative, as a consumer. Fuck you. We can modify or terminate this agreement for any reason whatsoever, provided we give you 30 days notice. So now, you opt into 1.1. Theoretically, somehow, some way, your brain cells just stopped working, and you went click, and you went, oh my God, I agreed to 1.1. All right, well, I sold my soul to the devil. Or Orca. No, it wouldn't be Demogorgon. And here's the thing, folks. It's irrevocable. Even if somehow, by some miracle, they decide, holy shit, like 19,000 companies are filing lawsuits against us. If you've signed up for 1.1, guess what? Your 1.1 is what you're under. Don't give up your rights by opting into a contract that is going to fuck you over. I am not a legal professional. I am not giving legal advice. I am giving friendly advice. I wouldn't touch 1.1 with, I don't know, a 10-foot pole. There you go. It's what we all would have in our backpack. Yeah. I got a 10-foot pole in my backpack. No, you don't. But in any case, 30-day notice, they can change whatever they want. They can modify, they can terminate it. No necessary reason other than, hey, I woke up on the wrong side of the bed this morning. I am going to fuck. If you misuse or infringe, they can terminate it. If you terminate it, you got to give them written notice. Okay. We know this may come off as strong, but this is important. If you attempt to use the OGL as a basis to release blatantly racist, sexist, homophobic, transphobic, bigoted, or otherwise discriminatory content that ends with an IST or IC, or do anything we think triggers these provisions. Okay. Your content is no longer licensed. To be clear, we want to and will always support creators who are using the OGL to help them explore sensitive topics in a positive manner. But we will not tolerate materials we consider to be in any way counter to the spirit of D&D. Now, I would like to see put into this contract a definition of what the spirit of D&D is. I don't know what it is. I don't know. I know what the spirit of the gaming community is. I don't see it in this contract. In any case. Additionally, you waive any rights to sue over our decision on these issues. Okay. We are aware that if we somehow stretch our decision of what is or is not objectionable under these clauses too far, we will receive community pushback and bad PR. Got news for you, dumb fuckers. You've already gotten the bad PR and the license isn't even out and you haven't even banned anybody yet. That, I swear to God, is that's a natural 20 or natural one, I guess, if it's a save. And we're more than open to being convinced that we made a wrong decision. No, you're not, because you'd have to be open to the fact that this contract, this license, is the wrong decision. But nobody gets to use the threat of a lawsuit as part of an attempt to convince us. Okay. Upon termination of this agreement, you will cease all sales and distribution, but you still owe us monies. Okay. All right, so we're gonna scoot ahead because we're giving you a license, not agreeing to take on potential liability when we do so. To be honest, we're not really sure what we could do while making Dungeons and Dragons content available to you that could ever be grossly negligent, but our lawyers say we need to include that last clause under Washington law. So in it goes. All righty. And we will keep us. We're going through all this, the legalese here, and now we're getting to the commercial terms. Okay, and again, it's the same thing. You got to go to court. Well, no judge. You give up your right. You give up your right as an American citizen to a jury trial. You give it up with this, and that's a huge thing. I don't know why you would go to trial against them, but if it happened, you give up that right of being heard by a jury of your peers. Keep that in mind. Content covered and not covered. It's again, this is similar to what we saw before in the non-commercial. Ownership, again, you agree we own copyright, trademark, and patent rights, if any, in the licensed content and the unlicensed content. We reserve all rights not expressly given to you through this agreement. You give up a lot. You give up a lot. So now, again, they tell you how you can identify things. Leveling up on this agreement. If you thought, and I know some people are like, oh man, interest rates are going up. Oh, I can't believe I'm trying to buy a car. They're charging me 6% interest. You ain't seen nothing yet, folks. Trust me. So we've already heard. All right, you got to register your work, and then once you've hit 50,000, you got to give them your revenue, but they're not gonna tax you on it. They just want to know. By the way, if you do happen to level up to the expert tier, they may reach out to you for a more custom and mutually beneficial licensing agreement. In other words, we ain't not just pound you in the ass that hard. We may give you a little bit of a reach around at the same time. Again, ask your dirtier friends. I'm not going to explain what that means. So, second time I've had to use that phrase in doing these videos. Why the tiers? Well, one thing is Dungeons and Dragons, and even our lawyers play. It's possible we're not actually sure how to design something without some form of leveling up. Fuck you. Also, we're trying to minimize the burden on our creators as much as possible. There was no burden on you all before. Remember that. We're trying to minimize it, as you'll see below. If you're in the Initiate tier, all we need from you is some basic information about what you've created and are offering for sale. Once you work your way to the Intermediate tier, we'll ask you to provide annual financial reporting so we can see what the royalties are due. And then, once you reach the Expert tier, you will pay us royalties on your revenue over $750,000. If you're doing incredibly well, you may level up to a custom license. Well, isn't that great? Registration, no matter what tier you're registering. Contact information, description of your licensed work, its title, where you intend to sell it, or where you intend to publish it. Sorry, we intend to publish it, really. And its price, among other things. Reporting at 50 in gross revenue, not profit. This isn't the money that you make after expenses, after paying your artists and writers and layout and editing, and give Kickstarter their share and the tax man their share. And again, assuming you're doing a Kickstarter, giving the payment processor their share. Doesn't make a difference. They want your grand total. Okay. You will need to provide us with year-end numbers by, again, February 15th of the next year. And they apparently haven't decided the method of reporting income yet. But royalties, 750,000 is the point where you start getting taxed. And if you make $1 million, you are going to get paid, or you got to pay a tax of 25%. Okay? Or 20% if it's on Kickstarter. Well, if it's on Kickstarter, on $1 million, it's 50,000. If you are not on Kickstarter, that's what, 62,500. That's a lot. That kicks in. That could eat up all your profit. But don't worry about it. Don't worry about it. Maybe you can't pay on time. We'll get to that. This agreement is effective January 13th, 4 days from today. No royalties will be due. Oh, and that's by Friday the 13th. So if that isn't another way to tell you to go fuck yourself, they've done a great job of it. No royalties will be due on any income earned before January 1st, 2024, no matter how much that income is. So we're going to give you a year to get out of the business. We want to give our community a lot of lead time to plan for this. So clarity, all other requirements are in effect from the time you enter the agreement. Now, by the way, remember, they can give you a 30-day notice and they can change anything they want in this license. Well, now we're going to be charging maybe 10% of everything over 50 is better for us. Why do you think they want to know your money is at 50? They want to know. They're going to be crunching those numbers and figuring out what's the best point to bring that royalty number to. If you're on Kickstarter, they only only charge you a royalty payment of 20%. Anywhere else, 25%. Okay. And if you have mixed revenue, royalty payments are due on or before March 31st of the succeeding year. For example, if 1,000 in royalties is due for 2024, you must pay us 1,000 before March 31st, 2025. Pay us on time. If you don't, we reserve the right to charge interest at either, and this is great, 1.5% per month or the maximum amount permitted under applicable law, whichever is lower. So if your state somehow sees 1.5% as usury, then maybe you get taxed at a lower amount. But most of you are looking at 1.5% per month, and I am not even sure how that compounds out. That's 18% before compounding. Yeah, pay us in full. If you don't, in addition to paying the unpaid royalty and any applicable interest for late payment, you will be charged the actual cost of reviewing your records if you underpaid by 10% or more. So
they're very enticing.
So yeah, so not only say I literally can't afford it. The project just barely made money after it got caught up in shipping in books from China. You don't have the money, right? Not only are they going to charge you interest, they're reserving the rights. Oh no, actually no. If you don't, you will be charged actual costs of reviewing your records. Not may. See, they reserve the right, mind you, to charge you interest, but they will charge you the actual cost for reviewing your records. That's awesome. That's the company that I want to sign a contract in blood with. You must keep complete and accurate records sufficient to confirm your compliance with this agreement, including the calculations of amount due for a period of 3 years after each royalty period. In other words, if you have revenue, I'm laughing, from licensed works in 2024, you'll need to keep those records through January 1st, 2028, because we are the fucking IRS. We are the IRS. We're the internal revenue service for Wizards of the Coast. If we ask, you will provide us with copies of your records relating to revenue earned from your licensed works, including those records you use to calculate the amount of royalties due to us, so we can confirm the calculations of those amounts and audit your royalty payments. If any mistakes were made, you agree to promptly pay us the amount that was not paid, plus any interest due. We want to be crystal clear about this. Royalties are only due on amounts over 750,000. I don't think anybody's going to be unclear about that. People are going to know when you start taking money from them. We know these calculations can get more complicated if you have some work funded through Kickstarter and others that aren't, but please don't stress about it. If you have questions about your particular situation, reach out to us at accounting scumbags at wizardsofthecoast.com and we'll work through them together. Fundraising. We don't object to you crowdfunding your licensed works, but we need to address concerns about overreaching and prevent the funding of infringing products. Because of that, this section has very specific requirements. Okay. You may only crowdfund the production of licensed works. Wait. Does that mean that I can't crowdfund the non-OGL works? That's an interesting question that, again, comes up because no infringing materials will be giving out as perks or rewards. The primary product for your campaign must be a licensed work, such as a campaign setting. You may have stretch goals that are not licensed works, provided they do not infringe upon our intellectual property. For example, a dice set with your company's original logo, but not with ours, is permissible. You may also have stretch goals that would otherwise qualify as licensed work, such as modules and adventures. These additional modules and adventures do not have to be registered separately with us unless and until you decide to sell them separately from the campaign. Oh my God. Revenue from any add-on materials that backers separately purchase is not considered qualifying revenue unless the add-on is also a licensed work. So you can, there's your mix. I'm not going to go through the examples. Again, 18 years of age, have the authority. You will not state that your works are endorsed by or associated with, except you have to put the creator product badge on all your products. You will not use any content or works covered by Section 1 for any harmful, discriminatory, illegal, obscene, or harassing purposes. You will do not anything to harm our reputation, that of Dungeons and Dragons, or the reputation of licensed content or unlicensed content. For purposes of clarity, this provision does not apply to criticism of Wizards of the Coast, Dungeons and Dragons, or the licensed content or unlicensed content that does not independently violate these provisions. Okay, so I can still criticize. That's good to know. I'm glad I'm not violating the OGL by talking about the OGL. You will not attempt to circumvent or go around this agreement in any way, such as by creating separate entities to try to evade payment of royalties. And there you go, folks. That is the piece that there were because there's really, they're talking about things in here. They want your money. They want your content. And your content it's just an income stream for them. Okay? So if you created two companies, the theory was, I've got company A, I've been publishing under the 1.0 open game license for the last 15 years. Oh shit, 1.1 says I'll make another LLC and that'll be my 1.1 OGL company, and I'll keep under the old OGL. No. Thank you, folks, for adding that in because, this agreement may be modified with 30-day notice. It may be terminated pretty much without notice. We know this comes off strong. Same thing as in the non-commercial. If you do anything that's an ist or an ick, or occasionally an ed, and otherwise discriminatory content, you're over it. You're done. Over and done. So, other products, sometimes great minds think alike. We can't and won't cancel products out of fear that they'd be viewed as similar to licensed works. Therefore, nothing prohibits us from developing, distributing, selling, or promoting something that is substantially similar to a licensed work. You own the new and original content you create. You agree to give us a non-exclusive, perpetual, irrevocable, worldwide, sub-licensable, royalty-free license to use that content for any purpose. For clarity, nothing contained in this section impacts your agreement that our licensed content, unlicensed content, or anything else you are not otherwise expressly authorized to use under the terms of this agreement or other agreement remains our sole property. Ugh, I am exhausted. Oh, by comments, we are giving you a license, not agreeing to take on potential liability. There you go. So that's the whole thing with because this is repeating the same thing as in the non-license. Review by counsel. Oh, by the way, again, they repeat the waiver of a jury trial. You agree that you have reviewed this agreement carefully and have had ample opportunity to obtain advice as to the meaning of the terms and agreements contained herein from such advisors, including attorneys, as you deemed appropriate or necessary. So they're telling you, have an attorney review this.
And your attorney will tell you, don't do it.
Don't do it. Walk away. Walk away. All right, folks. It's probably
Run, don't walk.
Run, don't walk?
Yeah.
Wow, this went much longer than I expected. All right, folks, listen. I'm going to include a link to this so you can download it and do with it as you will. Whatever you do, my suggestion, my belief, don't sign it. Okay? Don't sign it. There is resistance to this 1.1 OGL out there amongst publishers, large and small. Support your publishers. Support your independent publishers. And by independent, I mean anybody at WotC. At this point, WotC doesn't deserve your money, doesn't deserve your hard-earned greenbacks or your credit card. Give the money to the companies that are creating imaginative content that Wizards of the Coast is doing their best to stifle. All right? Be safe, be well, God bless. Roll those dice, roll them well. I will be back again tomorrow. Maybe I step away from this. Maybe. Now that I've read the whole fucking bag of shit. One can only hope.